Most people are going to try and avoid violence at all costs, but unfortunately, there are times in life where you just have to act with force. And so in this video, I'm explaining the law regarding self-defense. My name is Jamahl Kersey, and I'm the principal attorney at Kersey Law, a boutique criminal defense firm. And in this video, we're talking about the rules regarding self-defense. Now, there are 4 instances when a review regarding self-defense are generally going to come up in the law, and I'm going to explain each one of those because it is illustrative of how the rule regarding self-defense ultimately plays out in the real world. Now, the first context is going to be the law enforcement investigation and determination if a person is going to be arrested. So when we're talking about self-defense, there's going to have been some sort of violent act committed, right? And it could be anywhere from an assault to an assault with a deadly weapon, all the way up to a homicide, so where there's actually been the taking of a life. So there's going to be a violent act committed, and the law enforcement is conducting an investigation to determine whether a crime has been committed and if they're ultimately going to arrest the person for criminal charges. Once that assault has been committed or the violent crime has been committed, then they can look and see if they believe that the person was acting in self-defense, right? And if they're acting in self-defense, then law enforcement has the discretion to decide, our investigation is closed. The person was acting in self-defense. We're not going to push the case any further. Now, they could decide to close out the case, or they could push it up to the next level in our discussion, and that's going to be review by a district attorney, right? So once law enforcement has conducted their investigation, they're going to take their witness statements, police reports, photographs, videos, any other evidence that they have, and turn it over to the DA's office for review. And then the DA's office is reviewing to determine whether they're going to file charges against the person. And so they're looking to see if they're going to file the assault charge or assault with a deadly weapon or whatever charge they're looking at. But they're also considering whether the person may have been acting in self-defense. And so at that DA level, they could also make the decision that, hey, we're going to close out this case at this point. We're not going to file charges against the person if they believe that the person was acting in self-defense, right? But if they determine that they're going to file charges, so they decide to file the assault charges or whatever the violent crime is, then the next step is going to be that the person who's accused is going to get charged. He's going to enter his not guilty plea. And at that point, once he has his defense attorney, the defense attorney might review the evidence with them and determine, hey, I think you were acting in self-defense. Or, the person's going to say, hey, I was defending myself. I was acting in self-defense. And so it would be at that point where the defense presents the information to the DA and they say, hey, listen, we know that you've charged our client with this assault or this homicide or what have you, but my client was actually acting in self-defense. So at that point, the DA then may be reviewing whether the person was acting in self-defense, right? So they would be looking at these elements to determine whether the person was acting in self-defense. And if they make that determination, then they could dismiss whatever charges that they filed in the interest of justice. So they can file a motion to dismiss and the case would be closed at that point. However, if they decide, hey, we don't think he was acting in self-defense, or we don't think one of these elements was met, then at that point, if defense and the prosecution cannot come to an agreement on whether the case should be dismissed, then the case will have to go to trial. And at that point, it would be a jury who's then looking at these elements to determine whether or not the person acted in self-defense. And so one thing to bear in mind regarding the burden of proof is that it's not on the defense to prove beyond a reasonable doubt that they were acting in self-defense. No, on the contrary, once the issue regarding self-defense is raised, it is on the district attorney to then prove beyond a reasonable doubt that the defendant was not acting in self-defense. So that's a really important issue on the topic of the burden of proof. But nonetheless, we've gone over 4 instances where there could be a possible review regarding self-defense and a determination made. Again, that's going to be police investigation, then the review by the DA as to whether they're going to file charges. Then it'll be the review by the DA after charges have been filed. And then we're talking about the review by the jury because now we're in trial. So now let's look at the elements of self-defense. And so the first element is going to be a reasonable belief that there's danger of imminent bodily injury. All right. And so it has to be a reasonable belief. It can't just be some random, thought. It's got to be a reasonable belief. And then it has to be a danger of imminent bodily injury. So not some future harm. It's got to be imminent, which means immediate present danger. All right. So let's just use as an example. Let's say you have a guy come up to you and he says, hey, give me your watch right now. Right? In a threatening tone. It's not a person that you know from anywhere. So in that situation, that is going to put you on heightened awareness, and you would have at that point a reasonable belief that there's danger of imminent bodily injury. Somebody who is prepared to make that threat towards you may very well act on that threat. He could have a knife on him. He could have a gun on him. There could be another party involved. So in that situation, there is going to be a reasonable belief that there's danger of imminent bodily injury. Right? Compared to a situation where if a guy approaches you and he's not, he doesn't have a threatening presence about him, and he just asks, hey, can you give me the time of day? If he asks you that question and then you just give him right cross to the face, listen, we're going to say, hey, there is nothing reasonable about your belief that there was imminent danger. This guy just came up to you and asked you for the time of day. You're going to be arrested. You're probably going to be charged and convicted of assault because you're using force in that situation is not going to be reasonable. All right. So then the next element is going to be a reasonable belief that the immediate use of force was necessary to defend against the danger. So whatever the danger was that we talked about, if we've established that there was a reasonable belief, then you are able to use immediate force in order to defend from that danger. All right. And so the last element is going to be that you used no more force than reasonably necessary to defend against the danger. All right. So there could be a situation where, let's go back to our example, where the guy asks you for your watch, and we already established that it would be reasonable. It'd be a reasonable belief that there's danger, right? And so if you decide to punch the guy in the face in order to defend yourself, and you land a good shot, you knock him out cold, he's on the ground. So let's just say he's on the ground and you're now walking away from the situation, and you start to think to yourself, I can't believe that guy tried to steal my watch. And you go back and you start going and kicking and stomping him. Now, in that situation, we're going to say, hey, the original punch to the face is going to be justified in self-defense. But when you went and started kicking him, now you used more force than reasonably necessary to defend against the initial aggression. And we're going to say now you've committed an assault, and maybe even, depending on the type of shoes that you had, could be considered assault with a deadly weapon. So those are the elements of self-defense. And when this is in front of a jury, they would be looking at instructions that have these so they can analyze and determine whether the person was acting in self-defense. Now, another issue that comes up is whether there's a stand your ground rule. Now, here in California, we do not have a codified stand your ground rule, but there is, in the jury instruction on self-defense, there is an instruction that talks about this, and it says that a defendant does not have a duty to retreat. So there is no duty to retreat. And in fact, the person can, in fact, stand their ground and defend themselves. And in fact, you can actually pursue an assailant. So you can go after an assailant until you can continue to pursue until the danger of that bodily injury has passed. Right. And so, again, this part is really important because, even if you could have retreated to safety in that situation, you are still permitted under the law to pursue a person until the danger of bodily injury has passed. This is a very important rule because ultimately, if the jury decides that the person acted in self-defense, then they would have to issue a not guilty verdict on the issue of the assault or the assault with deadly weapon or violent crime. All right, so that's a brief overview of the law regarding self-defense. I hope you enjoyed it. If you got something out of it, please hit the like button, make sure you subscribe to the channel, and turn on the notification bell so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.